Thank you so much. Welcome back from lunch. I hope everyone had a really good lunch. This is session 2B, Guardianship or Not, Model and Ideal Approaches to Evaluating Capacities and Exploring Less Restrictive Alternatives. We have some very special speakers for you this afternoon. First, we have Honorable Patrick Woodward, who is a retired senior judge from the Maryland Court of Special Appeals, which is now known as the Appellate Court of Maryland. We have Megan Rusiano, who is a staff attorney from the Center for Public Representation, and Nisa Subasinghe, who is a domestic and guardianship program manager with Juvenile and Family Services at the Maryland Judiciary's Administrative Office of the Courts. First up, we have Honorable Patrick Woodward.
Good afternoon, everyone. It's always challenging to start off the afternoon. Everybody's had lunch. So we will try to keep it a little bit lively as we go along so that you will be engaged in what we're trying to present here today. I have been very fortunate over the course of my 35 plus years on the bench that I've done a lot of work in the area of guardianship on the trial level, on the appellate level. And I have been drafted as a senior judge to do a fair amount of work in the guardianship area. And so I'm happy, and this is one of my passions. And the great thing for all of you to look forward to when you're retired, you get to choose what you do instead of being told what to do. So that is what is. We have the indication of the notice to us or about us. Okay, let's start off. Why are we talking about alternatives to guardianship and conservatorship? Why are we even bothering to talk about this? Well, there are three really issues that pop up when you're dealing with guardianship and conservatorship. And the first is the individual. Obviously, the focus of attention is the individual. And we're looking now not anymore at diagnoses, we're looking at capacity. What capacity does this individual have? What lack of capacity does this individual have? What alternatives, what supports can you provide in order to address the particular needs? It's very individual focused. It's not just say somebody's diagnosed with dementia and therefore they need a guardian. We're also looking at alternatives to guardianship, and we're looking at, well, what do we mean by alternatives to guardianship? And then finally, if we find that an individual is in need of a guardianship or a conservatorship, the question is, does the individual need a full guardianship, or there can be a limitation or a limited guardianship that the individual should need as a part of the court process? So again, why are we dealing with alternatives? So let's be more specific about what we mean by talking about the alternatives. Guardianship, a full plenary guardianship, is what we call civil death. The Congressman Claude Pepper said, and I like to read this to everybody so that they can understand what guardianship really is about. The typical person subject to guardianship has fewer rights than the typical convicted felon. They can no longer receive money or pay their bills. They cannot marry or divorce. By appointing a guardian, the court entrusts to someone else the power to choose where they will live, what medical treatment they will get, and in rare cases, when they will die. It is, in one short sentence, the most punitive civil penalty that can be levied against an American citizen, with the exception of course, the death penalty. That's what in the very basic we're doing here. You are stripping an individual completely of all of their civil rights when you grant a full plenary guardianship. So in doing so also, you are depriving the individual of self-determination. They can't make any choices. They can't choose where to live, who to live with, how to travel, what doctor to get, what treatment to get. They lose all of that. And they lose their right to property if it's a conservatorship. It's also, we find over as a practical matter, difficult to get out of. I just have to say 2 words: Britney Spears. If anybody had followed that guardianship, how difficult it was for her to get out of it. She had to go to a court and ask for permission to hire a lawyer. This is what has happened over the past, in practically speaking, in the course of guardianships. And of course, guardianships do have limitations. Guardianship should be always considered a matter of last resort. Always, always. In the District of Columbia, this concept of capacity, let's talk about capacity. This concept of capacity rather than diagnosis is captured in the statute in the District of Columbia, an incapacitated individual, which is an adult whose ability to receive and evaluate information effectively and to communicate decisions is impaired to such an extent that he or she lacks capacity to manage all or some of his or her financial resources, or to meet all or some of the essential requirements of his or her physical health, safety, habitation, and therapeutic needs without court-ordered assistance. Okay, that's what's in the District of Columbia, and that's pretty typical around the United States. The ABA has a model rule called a client with diminished capacity, and this is broader than guardianship. This talks about the professional relationship between an attorney and a client who has diminished capacity. And DC has this rule of professional responsibility. Maryland does. I think it's something like, 38 states have it, at least have this kind of rule that's adopted by the ABA, and the states have taken that. Back in 2020, Maryland decided that that particular model rule needed revisions, needed amendments. So we embarked upon a 3-year study of that particular rule and made amendments to the rule that were ultimately adopted by our Supreme Court. And one of the things that we found when we looked at the model rule, when we talked about capacity or diminished capacity, the actual word should be, or the phrase should be, decision-making limitations. And that's the new phrase that's coming in. And frankly, it's a more accurate phrase of what we're talking about. But since we're stuck with what the law is now, we have to deal with what the law is. So we looked at it, and we looked at the rule, both the ABA model rule and the Maryland rule, and also the DC rule. There's no definition of diminished capacity. Doesn't exist in the rule. So we embarked to define it. And this ties in with incapacitated individual that I just mentioned to you. A diminished capacity means a decreased ability to receive and understand information, evaluate that information, and make or communicate decisions, even with the appropriate supports and accommodations, whether because of minority, mental impairment, or some other reason. And the way you look at this kind of definition and look at capacity in general is, let's think of it in a framework, let's think of it sequentially. When you're talking about capacity, you're talking about capacity to make a decision. So how do we make a decision? We make a decision by first receiving information. So you have to be able to receive information. And then what do? You evaluate that information. You have to take that and assess the pros and the cons and evaluate it against various options that you might have. Then you have to make a decision. You have to come to a decision. Some people have difficulty making a decision. Well, you got to make a decision. But then finally, you have to communicate it. And if there's a problem communicating a decision, then there is an issue regarding that. And then there's also this idea of supports and accommodations. Megan will talk to you about that in more detail. But supports and accommodations, I'll give you a very simple example. If you have a parent or grandparent that's hard of hearing, how do you accommodate them? You raise your voice. What's a support? They have a hearing aid. That's kind of a basic. We're talking about here is somebody who has a limitation about receiving information. So how do we accommodate that? How do we support that? Because with a hearing aid or raising your voice, there's no problem. There's no problem at all. So normally diminished capacity or decision-making limitations can come about when there is a temporary or permanent mental impairment. There can be addiction. There can be physical or emotional trauma. So a lot of times there's certain events that happen, whether it be physical, whether it be mental, whether it be others, that happen to the individual that can start this process or create this process where an individual has decision-making limitations. Well, let's get into the weeds a little bit about capacity. And this is where I think courts are way behind you all. We're way behind this because we're still looking at a diagnosis. We see a diagnosis of dementia, bingo, guardianship, we're done. It's your job to educate us that that's not it. And it starts with the concept of capacity. And so what is capacity? Capacity can be fluid. It can change from day to day. It can change from morning to evening. It is situational. It can depend upon where you are, whether you're in a courtroom, whether you're in the home of the individual. It can be also who's there. Is there a support person there? Is there somebody there that they feel comfortable with that can assist them? It can vary with the subject matter. Person may be very well have the capacity to say, I want to live with so-and-so, or I want to live in this house, or I want to travel to the beach, or I want to go see a show in New York, but not be able to determine whether they should buy Bitcoin or not. So it can vary. So capacity is not a on-off one thing or another. It's individual as to the individual. What is exactly the decision we're asking the individual to make? They may have, and it's that nuanced and individual focus that we have to be aware of. There are assumed biases, and Megan's going to get into that in more detail, but I just wanted to, one thing, this is, I guess the best way to call it is ageism, or people that are elderly, that it's a pejorative. Tell you one little story. I was on a panel of the appellate court, and an attorney gets up and starts off his argument and says, Your Honors, this case is about an elderly 68-year-old woman. I had a colleague on the panel that was 68. He said, Excuse me, counsel, I'm 68, and I don't think I'm elderly. But that's an assumption. That's a bias that's built into the system that we have to kind of take out of our lexicon. Because when you do have the biases, you're not treating the person as an individual. You're not according them respect. There's a colleague of mine, senior judge on my court, who's 94 years old, that is smarter than 95% of the lawyers and judges in the state of Maryland. Age is irrelevant. So, anyway, so much for my soapbox. But capacities can decline. Obviously, everybody knows that. Progressive dementia, not taking medication, over-medication. How about in facilities? You go into a nursing home for rehab, for a cracked hip, mental acuity can go down. And then you come out of it, bingo, it comes back up. So it can decline with a lot of stress, grief. How about physical trauma or being sick? How many times do you wake up and you're sick one day and you say, I'm just not with it today? How many people who are sick or in the hospital, they're not doing too well when it comes to their capacity because they're ill. Unnecessary or overly broad guardianships, those are another area that you can decline. If an individual is, and I've seen this in cases that I've had, if an individual who's whose values and wishes are totally disregarded by a guardian, taken away, depression, withdrawal can happen. And I've actually had a case that had that happen. The evidence was there. The guardian just decided everything and ignored the wishes and values of the protected person. Or the capacity can improve. Can improve with recovery from an accident, stroke. It changes in medication can improve one's capacity. With medical or mental health it can do, as well as supports and accommodations and less restrictive environments. So I'm going to turn it now over to Megan Rusciano, who's going to give you a lot more detailed information regarding the supports and accommodations and other things. She is an expert on it.
All right. Thank you, Judge. And it's always tough to follow Judge Woodward's words. So up here, just really briefly, if you Nisa put the words disability and older adult into a word cloud, and here are some of the words that came up. Let's see, feeble-minded, disadvantage, incompetence, decrepit, all things that sound really positive, right? So I want to take a step back, because one of the things that Judge Woodward underscored in kind of laying this foundation is the role that bias can play. And I think that there is a lot of assumptions about people with disabilities. And when we talk about guardianship, of course, we're talking about people with disabilities, older adults. I think that when you kind of look back at how professionals, and that can include attorneys, that can include medical professionals more broadly, kind of work with and approach people with disabilities and older adults, they often assume that a person may not be able to make a decision, right? Based on, physically how they appear, based on a diagnosis on paper, based on their age, as Judge Woodward has put out, based on physical impairments, if they're, whatever their equipment is. There's the other panel, there's a fantastic advocate, Thelma Green, who's quoted who's presenting now in the other panel, and she has a great quote in a video. It says, "People see my equipment before they see me." And I think that is really true and very powerful. Living situation, if you hear somebody is in a nursing home, if you hear they just had to stay in a mental health hospital, or they came out of a DD facility, developmental disabilities facility, there can be some assumptions or bias about how that might play out. And of course, there may be a consideration of a temporary medical or contextual condition that might impact a person's capacity. I worked with a woman who had a very significant case of depression after a very traumatic divorce. It manifested in almost appearing like she had dementia, but she did not. And she was put under guardianship, placed in a nursing home, even though she was really just depressed. So I think it's important to really look at what can be temporary. So those are some of the misconceptions. What are our realities? Where are we right now? People experience negative outcomes. We know when they're excluded from decision making. If we really look at what guardianship does, and I think what Judge Woodward really eloquently and powerfully articulated, and what former Congressman Claude Pepper articulated is at stake. There are these really negative outcomes that can come from stripping somebody of that ability. Not only the loss of rights, but the impact of that loss of rights. And so, focused here on a couple of studies that kind of pointed to experiences that older adults have had, and people with disabilities have had. There's one study is quoted, a person with Alzheimer's is quoted as saying, "People talk around me, about me, but don't talk to me." Another person remarked, "There's essentially no way for me to convince anybody that although I'm affected by Alzheimer's in many ways, there's still a lot up there in my mind that has reason to be communicated." Being labeled as incapacitated or incompetent can stigmatize an individual and result in learned helplessness, right? If somebody's institutionalized, they have the decisions taken away from them. They don't get to decide when they wake up or when they get a meal or when all of those things are laid out. And so it takes away that decision making, leads to a decline. I think to the flip side of that, people benefit from being involved in decision making. Research shows that retaining control and involvement in decisions about one's life actually correlates with improved life outcomes. So there's a study that's gone around, I commonly quote to, I know others do too, that people who exercise greater self-determination in their life have improved life outcomes. They're more likely to live independently, work in the community at higher paying jobs. They're more likely to identify situations where they could be abused and less likely to suffer abuse. I used to work at Disability Rights Maryland, so Maryland's P&A, and I was in charge of the VOCA grant, the Victims of Crime Act work that we did for people with disabilities. And this really resonated with my work there, because the more that it was clear that somebody's opinion and perspective was going to be valued, and that they had a right and entitlement for people to listen to them and to listen to what they said, the more people were willing to speak up. And in my work, I had seen that a lot with victims, people with developmental disabilities, women who had been victims of sexual abuse, of the idea of, if I stand up and say, if you teach me that my voice matters, if you include me in that conversation, then I can better stand up and say, no, this shouldn't happen to me. No, this is wrong. People who exercise greater self-determination also have greater financial independence and greater community integration. To kind of continue with that theme on the mental health side, if you're not aware of the work of Ellen Sachs, she's a law professor from USC. She's a MacArthur Fellow, so she received a Genius Grant. She's also a person with schizophrenia. She went to Yale Law School. She was repeatedly hospitalized. She was thought to basically have to live her life entirely in an institution. And now she kind of leads the way in a lot of ways, not only as a law professor in mental disability law, but also in psychiatry and psychology. But this is a quote from her that I found really compelling, and I included a link to it. There's a video, and I encourage folks to learn more about her, and she has a great book as well that you should check out too. She said, "For about 10 to 15 years after my last hospitalization, I made many efforts to get off medication, undertaking each effort with great gusto and failing miserably every time. Eventually, I followed my doctor's advice, and my life got immeasurably better. When I look back at that time, I wish I had gotten smarter sooner, but I was glad I was allowed to make my own decisions in my own time. Indeed, force is an untenable solution. If we encourage the patient to make her own decision, she is likely to be more committed going forward," right? The more you give that person the choice versus forcing it upon them, the more likely they will across time, and I know mental health is a journey, they will across time be more likely to come to that realization for themselves. So that's kind of the realities of a certain kind, and we can talk about the legal realities too that we operate under. So, how do we kind of deal with these biases? How do we deal with these assumptions, these kind of sets of facts that people with disabilities navigate, the realities people with disabilities navigate? Well, there is the Americans with Disabilities Act. Title II of the ADA requires that state and local governments, which includes courts, provide people with disabilities an equal opportunity to access and benefit their programs. So you have to have equal access to court programs. Title III of the ADA applies to places of public accommodation, which includes attorneys' offices. Section 504 of the Rehabilitation Act applies to any entity that receives federal funding and has similar requirements. Right? These laws require that if we're going to provide a service, if we're going to of any kind, that service has to be accessible. People with disabilities have to have an equal opportunity to access it as people without disabilities. And I say these things because I want to make a point here that I think is important. A lot of times people think the ADA is the ceiling. All I have to do is follow the ADA, and I've done everything right. And it's a great law. It's a law that we use to enforce the rights of people with disabilities. But I think there's a human way of approaching it as the floor, right? These are the legal obligations, the legal bare minimum that we need to do to comply. Just as there are ways to be accommodating to people with different backgrounds or different experiences in your courtroom, as an attorney, in your practice, and whatever that is, there are also ways to make situations more accessible and more accommodating with people with disabilities without always going, well, does the ADA actually require that? It's an important question, especially for a court, right, to consider. But for things that don't necessarily have to do with the administration of justice, I encourage folks to think of this as a floor, right? We can do a lot more, and we should look to see what we can do to make things more accessible. So what does this equal opportunity mean? There's a really critical element, I think, within Title II and similarly in Title III of the ADA that talks about effective communication. When we talk about people with disabilities potentially subject to guardianship, you're talking about clearly an issue with capacity, as Judge Woodward has said. And I think that the element of effective communication is really critical. It says that whatever is spoken or written must be as clear and understandable to people with disabilities as it is for people who do not have disabilities. How do you make that happen? You provide auxiliary aids and services. Get into a few of those later. They can look like, a CART, like a subtitling, or access to interpreters, or access to a supporter, or, change in an environment, or having more breaks. We'll talk a little bit more about accommodations in a bit. But what's important to remember is that that'll vary depending on what the person's disability is, and it'll vary within disability. If you meet one person with cerebral palsy who has a set of accommodations, you've met one person with cerebral palsy with that set of accommodations, right? It can vary extensively. Public entities need to give primary consideration to the aid or service requested by the person who has, that difficulty communicating or requires a change in something to ensure that they can effectively communicate their decisions. There's a great toolkit from the Department of Justice and guidance that's set out on effective communication that I've linked to here. There's also a settlement agreement that I tend to link to as well. It was a law office out of Michigan that failed to provide sign language interpreters to a client and was actually sued by DOJ to mandate that they provide those interpreters. So I feel like sign language interpreters are kind of our basic auxiliary aids and service. Hopefully that one's not too controversial. But seeing that play out and seeing the Department of Justice take that up, I think is important. So this is a quote from former Supreme Court Justice Ruth Bader Ginsburg. It comes from the Tennessee v. Lane decision, which was actually the decision Supreme Court that said Title II of the ADA applies to courts. Congress abrogated sovereign immunity to have it apply to the courts. In that case, a man with paraplegia was forced to crawl up the stairs of a courthouse to access his criminal hearing. And when he refused to do it a second time, he was jailed. And so this is the case, right, that says ADA does apply to the courts. And in her concurrence, Justice Ginsburg said, including individuals with disabilities among people who count in composing We the People, Congress understood in shaping the ADA would sometimes require not blindfolded equality, but responsiveness to difference, not indifference, but accommodation. And I think that that's a good way of framing what we talk about when we talk about accommodations. So Judge Woodward talked a bit about the rule changes that we undertook in Maryland under his amazing leadership in that, really pioneering work. I think that this rule is important, not only for attorneys to think about what our relationship to our clients are, but also, even if you're not an attorney, it presents a model, right, for how to accommodate and look at how to ensure that somebody has the communication supports that they need, and how to accommodate potential diminished capacity. So in our rule in Maryland, we recognize that in some cases a decreased ability to make a decision may be alleviated or eliminated by the use of supports and accommodations. So I work with a lot of folks who use augmented and alternative communication devices, AAC. So AAC is one element of AAC is a speech generating text. So let's say you don't communicate using verbally using your own speech. You're unable to kind of give a response. You might be able to type words in an iPad that generates speech for you. There's a phenomenal advocate. His name is Ken Capone. He eliminated subminimum wage in the state of Maryland. He led the self-advocacy group People on the Go for many years. He uses AAC. He's unable to, he has a form of cerebral palsy that makes it so that he can't use his hands. And so he types words out on a keyboard and generates speech for him, and that's how he talks. But every time I say this, I say, imagine Ken, whose parents always believed in him 30 years ago before that technology existed. What would we have assumed of him, and what was capable actually inside of him? So I encourage people to think about the ways that supports and accommodations can eliminate perceived disability. We're going to talk about these buckets. I want to kind of move us along. We're going to talk a little bit about supported decision-making and effective communication devices later. But I want to move it to Nisa to talk us about ideal. Sorry. Not helpful when I walk away from it.
You're right. So I know we've been talking a lot about capacity this day. I was even talking about it during lunch. My capacity improved with lunch, I will say that. And Megan's talked a lot about supports and accommodations. I know we've talked a lot about alternatives to guardianship as well. What I want to offer you today is a framework for taking that information we know about an individual, what they can and cannot do, and to help address their needs and to screen for alternatives to guardianship. I will say this framework works at any point. If you are working with a client or you have a loved one who may be struggling in some areas or to make decisions, don't jump to guardianship first. I think that's a theme of today. That's the last resort, right? What I want to offer you is a different way to approach assessing what they need. This is based on a assessment of guardianships in our state in Maryland. We talk to judges, court staff, attorneys, persons under guardianship, social workers, hospitals. We just put random people off the street and just started talking to them about guardianship. And what we identified is that, I think there's a lot of information out there, guardianship, our own court. We have forms. Well, it's easy to fill out a form, but there isn't enough information out there about the options. So this framework, we call it IDEAL. It stands for identify, evaluate, assess, and limit. And I'm going to walk you through those steps. So the first, identify. It means identify the person's specific needs and areas of concern. We really can't talk about what alternatives to guardianship are available until we get a sense of what they actually need, if they need anything in the first place. So I offer you here a way to organize some of the needs that we all have, or a way to organize how you look at a person. Is it that they are struggling to make decisions, or do they need some help making medical decisions or educational decisions? It's helpful to organize things, and some person may only have needs in one of these areas, or they have multiple, but identify those up front. The next step in IDEAL is to evaluate the person's capabilities and resources. I know we've been using the term capacity a lot here. Nina Cohn earlier said, really looking at what the person can do, their abilities, and that's what we want to look at here. I think there's an instinct when we look at guardianships or conservatorships to focus on what the person cannot do. And our systems also focus on a person's deficits, like our public benefit systems really do focus on a person's disability, what they can't do, but that's not alone sufficient when you're looking at a person. So in evaluating a person's capabilities, another theme of the day, we're not looking at someone's diagnosis. There are people with diagnosis in this room who don't need guardians, right? We are looking at somebody's decision-making abilities. And the standards, at least in the legal standards for decision-making, vary. The legal standard for entering a contract is very different than the standard to decide, Megan, where are we going after this summit today? We got to figure that out. What am I going to have for lunch? I had so many decisions at Union Market, but that's a different standard, right? I also want to say that bad decisions are not always a bad thing. I know there is a line, but being afforded the dignity of risk allows us to learn and grow. I make so many bad decisions. Megan's got stories, that's Relator. But bad decisions alone are not sufficient to show that somebody can't make decisions. They may not, the standard is not what decisions you would make. Or what I would, actually don't make any decisions that I would make, that should never be the standard. But again, we do want to afford people the opportunity. I mean, some of the best things I do are from the worst things I've done. So we want to make sure that we're not judging people based on our own biases or what we would do, rather giving them room to grow. And I get there is a line there. So, a lot of times when we talk about capacity, people, I've heard a lot of healthcare healthcare providers will say, well, they're incompetent. I'm like, well, doctor, that is not your decision to make. That is a legal determination. But that's not a good question. The question of whether somebody has capacity is a bad one. The better question is capacity for what? What are their needs? What are the decisions that need to be made to address those needs? That's a better question. And what resources can we put in place short of a guardianship to address those needs? And when you break it down that way, I think you might see more options. You might allow for more independence there. So Megan will talk a little bit more about some of the other, actually, no, Megan, it's now your turn. Can you give us examples of accommodations that might help somebody make decisions? And I'm going to stand up here really weird. Yeah.
Stand next to each other so we can figure out where we're going later. So, I think something that's really important in kind of that step in asking capacity for what is also asking, is there an accommodation for that? Is there something that can make that person able to communicate, more comfortable, like making that decision, communicating, evaluating that information as Judge Woodward kind of broke it down? And, I mentioned AAC devices. I think that is a really important tool. It's a growing tool. We're talking more in the disability space about trying to get connected to AAC at a younger age so people can learn cause and effect on an iPad, can type out so it's clear what people's intentions are, what their decisions are. Modifications to, kind of a wide example. The DOJ Effective Communication Toolkit and Guidance has a bunch of great examples, as does the resources at the end of the slide. These are just a few. I think for attorneys, modification to intake procedures, I can't tell you how many times I've called to try to get somebody legal help, and the requirement is there can't be a third party on the line, which is fair as an element of privacy, and I understand that as an attorney within the attorney-client relationship. But if someone says the magic words of, I need this person here to understand what you're going to tell me, then there should be a process at least for an attorney to evaluate that and to ask. I think a great modification to your intake procedures is to ask what accommodations a person might need. Physical changes to a courtroom or a meeting space seem really basic, but a lot of doors actually aren't as wide as they need to be. A lot of spaces aren't accessible. A lot of plugs are down low, not high. A lot of things are off if you have ever navigated the world in a wheelchair or even on crutches. Proceedings at certain times of the day. People think about sundown with people with dementia. I also work with a lot of folks who rely on paratransit in Maryland or Metro Access to get around. And notoriously, those systems are those structures where you or the systems where you will have a van come pick you up and bring you to a place are hours and hours late. I have waited after a 2 p.m. meeting until 7 p.m. with a client for paratransit to come. That did lead to a lawsuit in the state of Maryland that is ongoing and has taken a long time to fix. But, it's really, I think, being cognizant of if it's a 9 a.m. hearing or 9 a.m. meeting, is the person being late might not actually be reflective of, their inability to show up and be there. It might be dependent on others. Extra time or breaks, and we'll talk supported decision making. There's a separate session on that. I encourage folks to I know that DC was actually one of the first jurisdictions in the country to pass a law recognizing supported decision making. I think that it's a concept that's really important for us to recognize and understand the roles that kind of support and accommodation can play, because sometimes just having somebody there who can say, you're talking too fast, this person's not getting it, slow it down, or we need to take a break, or these are the accommodations this person needs. My partner knows me better than anyone. She can tell when I'm nervous before I'm nervous, right? Before I show it, just by facial expressions. And so that knowledge that people have of each other is really valuable in establishing communication and trust in a lot of our interactions. So I'll turn it back to you.
Thank you, Megan. And, Megan really introduced me to supported decision making, and we're all using it. I guarantee you every one of us in this room has used it. And so I use it. I love to talk about my mom when she's not in the room, and I'm kind of nervous by that camera right now and where this is going to be posted, but I'm just going to go for it. My mother, there are cultural things associated with this, but experience things associated with this, but she interacts with people in different ways. Lawyers and healthcare providers, we notice something different with her. She's very people pleasing, she always, but she also can be really petty. So when she gets the sense that somebody thinks she's stupid, and she has an accent and she's very sensitive about her accent, she is the smartest person in any room, but people tend to look down on her. People tend to think that she doesn't understand things. And the reality is sometimes because of the situation, she is not processing information the way she would in another context. When she is upset about something, she grew up in a former British island. They learned English growing up, but she doesn't always process information in English as well. So when she's nervous, when she is anxious. So my sister and I, like Megan's partner, we kind of get a sense of when she's just messing with you, which is terrible for her because it looks like she has less capacity than she does, and you'll find out later that she has plenty, but we can tell she's just people pleasing. She's just agreeing with you, but she doesn't understand. We can tell when she's getting overwhelmed. And so my sister and I being in the room with her is really important because we can tell when she's shutting down. We can tell she needs a minute. We can say, Mom, tell me, what did you just hear? Tell us what you think. We can help her ask those questions. If we weren't in the room, we're going to have to be calling the doctor. We're going to have to be having that permission to go talk to that lawyer about what happened. But that's supported decision making. She has capacity, but sometimes for her to really communicate or to make decisions, she needs one of us in the room. And she picks which one. I'm better in some rooms than others. We have feelings about it. It's fine. In addition to looking at a person's capabilities, we also want to look at the resources they have. Our family members, our friends, our community service providers, they are tools also to help maximize our decision making or to address some of the needs that we identified earlier. As I said before, there's a lot of information now out there about guardianship. There is not enough information about alternatives to guardianship. That is not a term that everyone is familiar with or comfortable with. We have to do a lot of education, all of us, around these options to avoid guardianship or help folks sort through the options. We also may need to ensure we are effectively communicating with family and friends. They may also need supports and accommodations to be partners with you. Of course, there are agencies. I used to work in DC. I am so missing you all. So I know you have services here. It's so great to be back here. But those are your community partners. Professor Cohn talked this morning about mediation. I have a lot of feelings about it. We can talk about that offline, but I do think it is an effective tool. Mediators have the ability to facilitate discussions with family about what options they are. Educate those family members about the options. Make sure the person who may be at risk guardianship is in the room and we are affording them supports and accommodations to meaningfully participate in those discussions. Mediation, you can have much more creative outcomes. Judge Woodward, you're a nice guy, but you're kind of a blunt tool. Like, you can't really do much as a judge, but there are more creative options outside of the court process. So So we've gone through the first two steps. We've identified the person's needs. We've kind of organized where their needs may be. We've evaluated their capabilities. We've evaluated their resources. The next step in IDEAL is to assess alternatives to guardianship and conservatorship. Again, this is a process that should happen at every point in the case. Whether you're thinking about guardianship, at the hearing, when you're a court, if you're here appointing a guardian, or after a guardianship in place. This isn't a one-time thing. Assessing alternatives to guardianship should happen at every single point. Look at this as a snapshot in time every time. Like Judge Woodward said, somebody's capacity could improve, could decline. Alternatives that didn't exist 6 months ago may exist now. So keeping this as an ongoing analysis. And when we talk to folks in Maryland, including that random guy on the street, they tend to think of alternatives as there's one to rule them all. No, you may need a number of options, and some of these can be put in place at any time. It's just people don't know they exist. This is, again, where our public education around these options really needs to improve here. So I want to offer you here an example of how to organize, once you've identified the needs, examples of alternatives that may be available to address those needs. And I'm putting at the top in red personal decision making, because the most least restrictive alternative, I know that's grammatically incorrect, but whatever, is allowing the person to make their own decisions. So it may be that they just need help or support making those decisions. Then you don't have to look at any of these other options. I'm not going to go through these or other sessions. I live in Maryland, you're all here in DC, you can probably teach about those options, but I just want to offer you a way to organize these options based on the needs that we identified earlier on. And if and only after going through the ID, the E, and the A, there are unmet needs that you are not able to find an alternative to guardianship that exists, then you may need to seek guardianship or conservatorship. But the legwork that you have done can really help the process and also ensure that any guardianship that is needed is limited to the needs that you've identified and based on what you know about the abilities of the person. This is a case-by-case determination. It allows for the person to maintain decision-making in the areas that they are able to make those decisions, but allows the court to provide an intervention to address the limited needs. It can help resolve conflicts. I do family law too, and I gotta say, I see ugly custody cases, but they get real dirty in guardianships. I mean, they have years to hate each other, right? And it's usually like, who got the bigger bike when we grew up, when we were small, who mom loved more? So those conflicts, again, this can be resolved with a limited guardianship. And those powers can be modified at any time. You can have a guardianship from 0 to 100. This is a best practice in the area. So for those of you who are working with folks who may be experiencing decision-making limitations, the work you do through IDEAL, you're creating a record, documentation that could help this person retain their rights, if not all of them, at least some of them, but also help the court see your work. Remember algebra? I forgot it, I hate math. But I remember show your work. This is where, for the courts, we don't know the people like you do. Right? You're in the community with these folks. The more information the court has, the better. What the person can do, what alternatives have you tried, have failed, what happened, who's involved in this person's life, what resources have they been connected with. That getting documented can really help the judges, I see a couple of them in this room, focus on what's needed and tailor that intervention. So those are my tips for you. Also, I'm just going to get, while I'm on the soapbox, as you got on yours, I'm going to get on mine. If you have not done so already, please work on your advanced planning. Do your power of attorney, your advanced directive. Talk to your people about supported decision making. I have this dream that when everybody graduates from high school, someone sits down with them, goes through these documents. We check in again when their brains are fully formed at 26, making sure they're okay with everything. But we really need to normalize talking about these things. My father-in-law, I talked about him a lot. I'm okay if he sees this. He thinks that estate planning is for rich people. And so he doesn't think about that. It's not rich people who end up under guardianship and conservatorship more often than not. We have to make these normal things to talk about, and that is on all of us, because guardianship, I'm so tired about talking about guardianship. I want to talk about burgers and the tacos I had earlier today. But I'm going to turn it back to Megan to talk about some best practices.
All right, now it's time for my short soapbox. I will bring us home on the short boxes, short boxes. Whew, sorry, y'all. It's been a long day. So best practices, kind of when we're approaching this, where can we start? Have accommodation policies. It seems very simple, but we say, I talk a lot about supports and accommodations. I talk about people asking for them. You know, what's even better if you have a policy and can say, fill out this form. Or here's the process, here's the person that you need to go to, here's the person who's going to make the determination. Doesn't mean you have to grant something every single time. We recently have passed a court rule in Maryland to kind of more clearly define our reasonable accommodation policy. I think that's really, really helpful. Document accommodation support needs in intake processes. What did the person need? What would they benefit from? We know we don't assume, if we can take away one thing, don't assume capacity based on diagnosis. Identify other resources and supporters and services that may actually help a person navigate challenges. I'm a big proponent of home and community-based services, Medicaid supports, which may actually prevent a lot of the dangers, address the concerns, if provided sufficiently to folks about safety, health, housing. Those services provide those options. If, to the extent you can, draft materials orders in plain language. There's a difference between plain language and easy read. Plain language is about a 7th to 6th grade level. Easy read is a little lower. Think about and know what your documents are in, right? Seek out ongoing trainings on these issues, right? It doesn't stop. It shouldn't stop here. I think lifelong learning is important. I want to be able to flip it back to Judge Woodward to kind of bring us home. These are some communication tips for working with people with disabilities. There is a resource, I think, at the end in our resources on the presentation that I did with Elizabeth Moran, who's formerly of the ABA Law and Aging Commission, now is the ED of the ARC of Colorado, that includes these communication and practice tips for working with people with speech disabilities, people with cognitive disabilities. There's a lot of basic things that you can try to implement in your practice to make it more accessible. And we also have tips for working with folks with visual disabilities and hearing disabilities as well. And I'm going to turn it back to Judge Woodward.
We always like to give you some takeaways at the end, and I think it bears repeating. Guardianship is a matter of last resort. Less restrictive alternatives allow for the retention of your basic rights, retention of autonomy, retention of decisional authority. Studies have shown that when there is an excessive or overly broad guardianship has a negative effect upon the emotional and physical well-being of an individual. Stated otherwise, least restrictive alternatives promote the highest quality of living for an individual with decisional limitations. I want to repeat that. Less restrictive alternatives promote the highest quality of life. And many of you have seen this. I've seen it. Highest quality of life for those who have decisional limitations. That's our focus. That's the message. That's what we're carrying away. And how do we effectuate that? We effectuate that with education. That's what these summits are for. That's what the programs are for, is to educate you who now are going to educate others, and especially educate those that wear the black robes. We are educatable sometimes. Okay. So, education is critical in all of these areas so that this message can get out. We say, it covers the whole concept of capacity, alternatives to guardianship, working with people with disabilities, supports and accommodations. These are all functions of education. We can spend a whole day on supports and accommodations if you wanted to. Change in the law. You can change the law. That's what it's there for. That's what people who are elected, whether they be in the judiciary or whether they be in the legislature or in your council, you can change the law. We were able to do that in the model rule 1.14 in Maryland. We were able to modify that through our Supreme Court. And I commend to you the fact that if the law isn't good, change it. Get somebody who will help you to change it. That's what the law is a growing, living organism and can change for the better. If you look at Rule 1.14, which is client with diminished capacity, we were able to clarify the role of counsel in guardianship proceedings. Your role of counsel is critical as an advocate, not as a guardian ad litem, not as a best interest attorney, an advocate. That is so important. Focusing on the client's abilities. We removed the implied priority of guardianship over less restrictive options, and we clarified the right to consult and retain counsel when an individual is already under guardianship. Is the right to get counsel to modify and terminate that particular guardianship. So I commend to you, as a takeaway, if your law needs changing, get together, and I'm sure there are many individuals in the legislature on the bench that will help you in getting it changed. Thank you very much. Questions?
Yes, thank you so much. We have a little over 3 minutes for a few questions, if anybody has any.
Want to read them?
Oh, you already have a question ready?
Okay.
Oh, perfect. Do you want me to read them? Yeah. I'm going to be honest. I got the wrong question sheet, so I might have to read number two. Yeah, sure. From the court's perspective, what is the most important evidence to present when petitioning for a modification or termination of guardianship? What ethical and legal obligations does the court have to ensure an individual's right to self-determination is restored?
When you're excuse me, when you're trying to here, let me get this back. When you want to modify or terminate a guardianship, obviously what I would want to know as a judge when I'm sitting there, what I want to know is what is the individual's capacity, capabilities now. I want to know what they are. They can come from family, they can come from friends, they can come from the existing guardian, they can come from doctors. Most importantly, I want to hear from the individual. The right to be heard. I want to hear from that person in a manner in which is conducive for that person under a guardianship to be able to communicate with me. There may be things that will need to be done. Maybe a courtroom is not a place. We may need to be somewhere else. I may need to use plain language. I may need to use give them time. I may need to have some, but I want to hear from them. That is the most important thing to me, to ensure that I understand what this person wants, what their values, what their wishes, what their abilities are, what they want. For many years, I worked helped to improve the juvenile system in foster care cases. In talking to foster care kids, the one thing that they said over and over and over again, nobody listened to me. Everybody get into a courtroom and decided who I was going to live with, where I was going to live, who was going to be my foster parent. Nobody asked me. If you have an individual who is under guardianship, who has the ability to communicate and wants to communicate, I, the judge, want to hear that. So that to me is the most important thing. I want to know where they are at that particular point to see whether a guardianship needs to be modified or terminated.
My question is, when someone is under a guardianship and they have some of their power, essentially taken from them, what is in place to make sure that the person who is making decisions for them is not abusing that power?
Communication with the court. Somebody needs to tell the court what's going on. There needs to be communication to the court. It doesn't have to be hire an attorney and file a formal motion. If I get a letter or if I get something like that, I'm going to act on it. So I need the court, as most cases in most states, the court is the guardian. The individual who is appointed as a guardian is merely the agent of the court. I'm the guardian. I take that responsibility very seriously. If something's going wrong, I want to know about it. And I will conduct hearings, or I will appoint lawyers, or I will appoint an independent investigator, or in DC, send out your evaluator. I will find out what is going on. But I need to know, and the court needs to know.
So definitely communicating with the court is important, but the courts are also receiving reports from guardians. And I know it's a self-report. People are going to share what they want to share, but the courts really need to be scrutinizing those reports and accounting. Sometimes what isn't there is just as important. So the court, you have an amazing probate decision, your judges really paying attention to what information is coming in and what information is not coming in as well. Your court visitor program, I'm so jelly about that you have folks going out and checking in. It is kind of the honor system otherwise, right? So, the court they don't know what they don't know. We can't send Judge Woodward out in every case, but really understanding what process is available here in DC to let the court know. We have folks here from the probate division who might be able to talk to you about more specific avenues.
All right, that is all the time that we have. So we're going to take a 15-minute break until 3:30.